Hello, TikTokers. Welcome to Real Law Talk. This question has been thrown at me about 1,000 times, so I would think that it requires some getting into. Bear with me, this video may be a little longer than the others because it requires a lot of analysis about courtrooms and tactics and the law. So, to begin with, this is a legal analysis. This is Real Law Talk. We don't do politics here. I take no political positions on any political figure. And the only reason I'm discussing Donald Trump is because there's a criminal cases against him, and they're legally relevant. The January 6th, in my opinion, is the most important legal case that's ever been done in the United States. The issues there have never been seen before, and they will ultimately end up at the Supreme Court. So let's begin by saying the vast majority of defendants in criminal cases in the United States do not testify. Reason number one they don't testify is a lot of times they don't have a good answer for the prosecution's questions. Number two, and sort of 40% of the time, is that the defense attorneys believe that the prosecution hasn't made their case. So what happens is all the defense does is attack the prosecution's case. So when the jury goes back to the jury room, all they do is start dissecting the prosecution's case. When a defendant testifies, the jury weighs the stories. They go, okay, he said this, he said that, who's telling the truth? Just like in your life, when two people tell you a story, you weigh them. When one person tells you the story, you judge that story. So it is pretty rare that criminal defendants testify. They do testify in certain types of cases. Assault cases, where people, he started the fight, she started the fight. I've seen a lot of defendants testify in that. Sex crimes cases, where usually it's he said, she said. I've seen a lot of defendants testify in that. Other than that, when you look through the whole plethora of public cases, the vast majority of defendants did not testify. For example, Kyle Rittenhouse testified, but that was a classic self-defense case, and he had to tell the jury what he thought. Okay, so let's move into the Donald Trump January 6th case. To begin with, he gets to see what the prosecution has put in before he decides to testify or not. Then he takes the stand. The problem with this is that case is so huge and there are so many witnesses. First of all, the cross-examination probably take weeks. Secondly, once someone starts testifying on direct in their own defense, something called opening the door can happen. And what do I mean? We've had cases where the judge makes a ruling and the prosecutor can't ask the defendant about X because it would be prejudicial. And that's the ruling. But then the defendant gets on the stand and opens the door to it and says, yeah, they accused me of this in 1992 and I didn't even do it back then. That's huge. That's called opening the door to your past, and then the DA can drive a truck right through it because you're the one now that have put it at issue. So we all know the public persona of Donald Trump. So when he testifies, he could very well open doors to things that the prosecutor wasn't even going to ask. The other issue is, depending how many people testify against him, he will essentially have to paint all these people, and some of them he hired, as liars or people that all have motives against him. The problem with that is he's alone on the stand. He's everything that he's going to have to come up with these ideas on the fly, or he's going to have to be prepped in a way to do that. So there are so many pitfalls to him testifying in the January 6th case. I do not see his attorneys recommending that he take the stand. However, there's also the political side of this, which we don't cover. But remember, he only has to flip one juror. 11-1 is not a conviction. And there could be a math where him and his attorneys do, where they see a juror they can pick off, or they believe they can. They believe they've been doing well in front of the jury, where he would testify. I don't believe he will. Everybody I've spoken to doesn't believe he will. But we're in uncharted legal waters now, so we have to all the past sort of trial experience. Everybody's trial experience, and I've spoken to the best appeals lawyers in New York City. I'm friends with some of the best lawyers in the nation, and everybody has the same view of this case. It is so unprecedented that a lot of this experience really doesn't apply. Uh, I mean, you do a federal drug case, there's certain things that happen. You do a DWI case, there's certain things that happen. And there have been important defendants. There have been governors, senators, but never the president, the former president of the United States. So the political issues are for someone else to discuss, but these legal issues are so vast. The other point I want to make is this. All of the legal issues in the case get decided by the judge. So Trump can't argue to the jury, oh, I was expressing, these are all lies based on my First Amendment. No, because the judge is going to make a decision on that. There's going to be motions to dismiss, and the legal decision will be made by the judge. Remember, the jury is only there to decide facts. All a jury does is determine facts. Was he there the night of the killing? Did he kill him? Did he have the knife? The idea of if this evidence gets in or what the law is all comes from the judge. So to reiterate, I do not believe he will testify given the amount of, given the size of this case, because it runs so deep and there's so much discovery. I don't believe his lawyers will advise him to testify, and that's real law talk.